We're going to reconvene the regular City Council meeting of DuPont back to order at 8 p.m. And this is how this next phase is going to go. Three-part process. We'll have a panel presentation to the council. Then we'll have council question, answer, and comment, dialogue, open dialogue. Then we will have public comments, and we'll have a public comment process. The public comment process will be similar to the previous town hall meeting, and our city clerk will pass out index cards and we'll group them once again. Panel, I'm going to ask you to please introduce yourself, and should you have other representatives in the audience here with you that have been involved in this process, please introduce them as well. And we will start with our own city attorney, Bob Sturbank.
I don't know where to go with that. I'm Bob Sturbank, the city attorney. And Bill Kingman is with me here at the opposite end of the table. He and I were at most of the meetings on behalf of the city.
Hello, my name is Pete Stoltz. I'm the permit manager for CalPortland. I'm here tonight with Doug Anderson, our Northwest Division General Manager.
Please stand.
Scott Nicholson, our Aggregates Division Manager. Jim Tweedy, who is the plant superintendent at DuPont. And then our technical team includes Tom Schott of Anchor QEA, John Small of Anchor QEA, and Lori Herman of Aspect.
Thank you. And is your attorney here as well?
I'm sorry. Oh, yeah, our counsel, Steve Bruce, is here as well.
Please stand. Thank you. Next.
Good evening. I'm Tom Sherwold, and I have the honor of representing the Environmental Coalition at this discussion. And if I could take a moment, I'd like to find those people in the crowd here. I know we've got Crystal Packer here, who is representing, she's the new executive director of the well, there we go. Much better. Of the Tahoma Audubon. She's been a part of the negotiations very much at the table, and before her, Brian Flint was there as well. Susan Markey, who is the Conservation Committee representative for the Black Hills Audubon. They've also been part of our discussion group over the last couple of years. Dave Peeler, who's the Director of Programs with People for Puget Sound. Mo McBroom is the Washington Environmental Council's Policy Director. She says that's the political director, everything but fundraising director. And I'm honored to be back here again tonight and giving you sort of a slightly shorter version of the presentation we did a couple weeks ago.
And then we have Sally.
Thank you. My name is Sally Totiff, and I work for the Department of Ecology. I'm the regional director for the region that stretches from the Olympic Peninsula down to the Columbia River and out to the coast. It's a privilege to be here tonight again. I'd like to introduce two people from the Department of Ecology. Tonight, Mike Gallagher is here, a hydrogeologist and a supervisor in our water resources program. Kim Schmanke, our communications manager for Southwest Region. I want to thank the council for the deliberations ahead of you. We stand ready to, answer questions and help you sort through what you need to do. Thank you.
Thank you. And thank you all for all of your dedication and commitment. It's been a long process to get us to this point. So with that, Sally, you want to kick us off? Or
Tom will be kicking us off. Thank you.
We're in tag team.
We decided to shake things up a little bit, so we
Sweet.
try to keep it fresh here. This is essentially the introduction that we gave last time, and we're going to use that as sort of a Reader's Digest version of this presentation we gave on the what was that? The 30th of June. Again, we are negotiators for this proposed settlement agreement for 2011. The Environmental Caucus was the organizations I just represented, we just introduced, and also Anderson Island Quality of Life Committee, Washington State Department of Ecology. We were quite honored throughout the discussions to have Sally a part of that. The Department of Ecology has been a very serious player in this dialogue. The City of DuPont, these gentlemen, two of the here for this, and CalPortland ably represented by Steve Roos and Pete Stoltz here at most every meeting along the way. So that's who's coming to you tonight to talk about what this agreement is about. Let's see. Uh-oh. More tricky than I'm capable of.
You need to turn the slide.
Tom,
Oh,
can I ask
okay.
a quick question?
Sure.
Are your attorneys here in the audience as well?
Oh, my apologies. I did not introduce Brian Chestnut, who has been here through this same process. So.
And he got up to speed quite quickly late last year, and we thank you for that commitment. Continue, please.
Thank you. Well, I guess we just went through this introduction, so I think I can just go to the next slide, because that's really just the groups that we have represented here. In terms of talking about the agreement, I think particularly important for your consideration is that this settlement does some things, but it also does not do a number of things. And I think that may be important to a number of citizens as they think about what this really does. In some ways, this agreement is the start of a process. The settlement agreement in itself does not allow any mine-related activity within the Sequatchie Creek Ravine. It does not remove or alter the rights and responsibilities of the 1994 settlement agreement. In many ways, this particular agreement is intended to supplement that 94 settlement agreement. It does not guarantee that any new mining will be permitted per se. This really would relaunch the permitting process for additional mining. It does not change any regulatory requirements. All the process elements that one would normally expect for an expansion of mining would be in play. And it certainly doesn't change or limit any public rights to review, comment, or appeal permit applications and decisions. This is really outside of the 94 agreement in some profound sort of ways. What this settlement agreement, the one that's presently before you for consideration, does do is it does establish a process and specific conditions under which the parties agree to support each other's interests as this process goes forward. And it does require CalPortland to restart the permit process with the preparation of a supplemental environmental impact statement for mining of both the north and south parcels considered together in this. It does prohibit dewatering and mining in the south parcel unless there are specific monitoring, creek restoration, and funding requirements that are developed through a group process and approved by the Environmental Caucus, and that those elements also get permitted. The plans and the permit processes have to be moved through the entire public comment process and full consideration. I think there was one more point there. I'm making sure I'm not missing anything. It certainly doesn't, let's see, where were we? Oh, okay. Oh, very important. That part of the process begins with a development that would, $200,000 fund developed by CalPortland to fund stakeholder input and restoration planning process, which is a first step towards a potential restoration project, which would be part and parcel of the rest of the agreement. Thank you. The general terms of the agreement also require CalPortland to set aside a 45-acre open space, including nearly a mile of Puget Sound shorelands. That's the region between the north parcel area that was being discussed and the shore zone of Puget Sound. It also requires CalPortland to grant a pedestrian trail easement in that 45-acre open space area. And it preserves all the regulatory authority processes and requirements that are normally a part of such a mine expansion. It also has provision in it that would allow CalPortland to suspend restoration funding if their permit is appealed, denied, or canceled through this process. So that along the way, you'll see that the process has several places where there are options for essentially deciding that the mining process is not working out the way we had envisioned in this process. We were, for my organization, the Squally Delta Association, and for the Environmental Caucus, we were very interested in helping restore and enhance the Ecology Creek. I think that's a vision that we've been tracing back to 1994 and before. We are very interested in protecting open space in Puget Sound shorelands. And one of the goals was to allow potentially responsible mining in the north and south parcel that would allow those other goals to be met. At the same time, there was the economic development that the mining company and the city were seeking. Is it really as far as we want to go on this? I think we really don't want to get a lot into more detail. And I think I would pass this over now to Sally to talk about more of the detail of the process.
Thank you, Tom. I'd just like to let Aaron know, I'm just going to kind of page through these slides. In the interest of time, I understand that many of the council members were present with us last week at the town hall meeting, and others were able to watch the tape-recorded video. So I appreciate the time that was spent then. And what we'd like to do is page through pieces of this presentation and pause on a couple that we really want to highlight that help explain the process as we envision the sequence of steps that must be met before you ever get to certain critical decisions. And if there's more questions, we can certainly come back on that, but we'd like to preserve the time for the council to ask questions as well as other members of the community that are here. So Aaron, if I'm just going to kind of cue you like this, if you don't mind. I think last meeting you saw that we gave some background that's Ecology Creek, and the area has been heavily impacted by a lot of activities over the centuries, and that the basin could use a hand these days, and people have been interested in figuring out how to do that for several decades, as has been alluded to earlier, and that in this settlement agreement, one of the areas that we found a common interest is support of a Ecology Creek restoration plan. And with that in mind, we came forward in our final settlement of a restoration plan, as well as Tom mentioned some work to preserve Puget Sound bluffs and shorelines and preserve the opportunity for CalPortland to apply and go through the full permit process for additional mining. I'm going to go ahead and move through this, Aaron, please, and keep moving, please. This was simply a map that shows the area that we're mostly talking about. Go ahead, Aaron, please. This is a close-up of the north parcel. We'll talk a little bit more about that in a few moments. If you could flash backwards, please, Aaron, for a moment, if I can get the light right. These are the areas that are the open space, preserved areas, and the shoreline of Puget Sound, which many folks here have probably seen and walked along themselves. If you could go along, please, Aaron. This is depicting the south parcel. This is the area over that currently has mining going on. Is that right? Did I do that right? No, wait. So this is the south parcel. Sorry about that. Go ahead, Aaron, before I get myself any further into. Oh, good. This is what I wanted to talk to you about. Mr. Kingman, have you passed out? If you could, this graphic. When tonight it was decided that I would attempt to walk you through the process. What I wanted to do was to try and make it as straightforward as possible. For members of the public behind me, what I've done is I've color-coded this graphic, and unfortunately it's not color-coded on the screen, to show that there's really three main steps in a review process that is represented in the settlement agreement. And what you see, let's see, how many people now, do council members have this before you? And People in the audience are now receiving that? Very good. What you'll see is that we've color-coded so that north parcel has a particular color green, south parcel has a particular color blue, and restoration has a particular color pink. And I call your attention to those 3 areas because that's what's very, I think, distinct about trying to understand what's a fairly busy time frame and set of steps. The settlement agreement is designed to lay out a process to work toward 3 things. How you would get to a restoration plan and implementation of it, how you would work forward through a process for north parcel permitting and mining, and what the steps would be to work forward for south parcel monitoring, permitting, and then mining. And so I'm again going to work to those 3 areas several times, so bear with me. I'm first going to talk about restoration because that's an area that's very unique about this particular settlement agreement. Restoration is something that in year 1 of the settlement agreement would be started by bringing on a neutral natural resource organization that would convene a stakeholder group and process to develop a restoration plan for Sequalichi Creek. This restoration plan would be working to come to a final plan sometime in year 2. So again, I'm kind of trying to show how this graphic works that way. In late year 2 and in year 3, a restoration plan would move into a SEPA process and the permits necessary. It would move through some steps that we need to coordinate with Joint Base Lewis McChord, and we can talk more about that if council would like to do that. The restoration plan also has some steps related to south parcel mining, but I will get onto that when I talk about the potential for south parcel mining, to point out that implementation of restoration happens out in about year 6 and 7. So just to recap, year 1, a restoration plan process involving people who are interested, a neutral natural resource organization running that process. That plan, assuming that there would be a plan that could be created that would meet the different goals for restoration, would move into permitting, and then there would be some other things happening before we'd actually get to implementation. So that's about a 7-year process to get to implementing restoration. So that's sort of one category that I think is somewhat straightforward to understand. Another category that's identified in process steps that's fairly straightforward to understand would be north parcel activities. And north parcel activities would start with environmental review. And the environmental review, as we laid it out in the settlement agreement, would include the environmental review that's necessary for consideration of permitting eventually a project for the north parcel and for the south parcel. So this is a place where the north and the south parcel are joined together in year 1 in the environmental review, which would be done by the city of DuPont with a supplemental EIS process. Should that process move through to its completion, there would then be the movement into north parcel permitting, which shows about 1.5 years long time frame, and then the opportunity to begin mining in the north parcel. So again, the north parcel has essentially sort of 3 main steps: SEPA, environmental review, permitting, and then moving on to the work to begin mineral extraction and mining, and that would move out into later years. South parcel, which is an area that I know many people in this room and myself are very interested in, how does that work? How does a process work to create checks and balances and opportunities to slow down or even stop what's happening with the process? And it all begins, again, back at the environmental review, which would begin in year 1. In year 1 and moving into a little of year 2, there would be, now this is where I want to bring my cheat sheet out, moving into south parcel monitoring. In the settlement negotiations, what we understood very clearly is that the ability for the South Parcel mining to happen, there is a number of checks and balances that need to be done. And a monitoring plan, which would be designed to test and track if South Parcel mining works as designed and as models would predict it to be, this monitoring plan is critical to be done up front so you get your assumptions built in, what you're going to measure, how you're going to measure it, so that as you move in later years, you have something to come back and compare against. So this monitoring plan would be looking at groundwater and how groundwater would be able to be moved around for restoration, for part of the start into Ecology Creek restoration, and how groundwater would work with South Parcel mining. And then in the long term, when mining is completed, how groundwater would be looked at for the long term for monitoring. This monitoring plan supplements what would be required by the typical regulatory process. And this is a monitoring plan, since it goes above and beyond the typical regulatory process, is something that the Environmental Caucus actually in the agreement is identified as having the approval responsibility. So this, again, is something that is beyond what typically would happen and has an approval step there for the Environmental Caucus. When this is done, there's some other steps that need to be done with South Parcel ideas. Some of these are down here. I'm not going to go into these boxes right now. I'll see if there's questions about that. But when this monitoring plan is done, we can then move on to South Parcel permitting, should this monitoring plan be approved. And in that permitting process, you would be moving then through another step to coordinate with Joint Base Lewis-McChord, and a more formal step where we would, once Joint Base Lewis-McChord would see that permits had been issued, they are in a position where they can provide what they call consent. And then we would move into, again, this is in the blue area of your flow chart, another step of checks and balances is that pump testing and pre-mine dewatering would be done, and you can see that happens about year 4 and into year 5. And when that work is done on the ground, you'll be able to test some of what's been predicted in the monitoring plan and what's been portrayed in some of the SEPA and South Parcel permitting information potentially. I don't exactly know what the project will look like. We don't have a project on the table, so some of what I'm saying is based on sort of speculation of what a project might look like. When we're back at this first step, we'll have an actual project that I assume CalPortland will provide to us. So keep in mind what I'm saying is general in nature. But in this pump test, you will be seeing what happens and being able to check to see if our modeling assumptions and other things are accurate. And if so, what we're able to predict is that that's where adding some water from dewatering to Edmonds Marsh in the start of restoration could be done. Some, not all, because you have to be careful about how much water you put into a system as you start the work of restoration. And that will be tied to the restoration plan. That's why you have all these other steps proceeding. And then, assuming you get data, you make adjustments, adaptively manage what's going on. South Parcel mining could conceivably begin then, toward the end of year 5 into year 6 and 7. So again, South Parcel mining is by far and away the most complicated and the most rigorous. We believe that we have a number of checks and balances in places where we can take timeouts. That's what these boxes refer to in the settlement agreement. If things don't work the way that we have predicted or some assumptions have been, there is the chance to pull out of the process and meet and confer at this point in the process and also in this point in the process. Again, as we don't have a particular project before us today, what this process does is it lays out steps that we conceivably believe can lead us to the ability to achieve these results. We had a number of people helping us think about this, both technical as well as legal, as well as representatives from your city and my agency looking at the regulatory side. we believe that as a process, this has many steps that will lead us to what we hope can end in a very, very good restoration for the community. We think that it allows CalPortland the opportunity to apply for permits to do some additional gravel mining. The other piece that I definitely highlight often as I'm talking to my colleagues at the Department of Ecology is the additional protection of some Puget Sound shorelines and bluffs. Living where you do, you live next door to some incredible areas of Puget Sound, and it's not to be taken lightly, the ability for some additional conservation and preservation of those areas. So I'm going to leave that graphic as is. There may be some questions a little bit later. And Aaron or Dawn, should we just...
Next step in the process is we're going to open it up for council comment.
Sure.
And questions. So council, I'm going to open it up to you. I have the queue here. Councilmember Ehrenreich.
I just wanted to start off by saying how much I appreciate the work that all of you put in on this on behalf of our city. We have a long way to go before we get to fruition, both on a vote that we have to make here and if we go forward with this. But in the meantime, I did have a couple questions, and can you outline either now or sometime be more specific about exactly what the city's role in this process would be, assuming the city agrees and we move forward with an agreement? What are the decision points that beyond the initial year one or the initial approval of the agreement where the city is going to be involved? If you have the answers to that now, that'd be fine. If not, I'd appreciate.
Do you want me to take a whack at that? The city's role in the process will be primarily the entity that conducts the regulatory process. So the first, Sally was going through the SEPA process, and I don't have the pointer, but the upper left-hand corner, the SEPA, this way? I don't want to blind anyone with this. Okay, the SEPA box here, the environmental review process. The city would be the lead agency is the term in the SEPA lexicon. That means the city is the entity responsible for producing the environmental review and subjecting that to whatever additional process there is. The city would also be the entity in charge of the permitting process, not only for the north parcel mining, but the south parcel mining and the restoration plan. For both of the mining proposals, the permit process is a conditional use permit, which is reviewed by the city's hearing examiner. It's then appealable directly to the Superior Court. Does not come to the council for a decision. The restoration plan, since the particulars of that have not been designed yet, it's not clear sitting here today exactly what the procedure would be. I don't know if my colleagues over here have an opinion. Mr. Roos or Mr. Chestnut may have an opinion on what the permit process might be. It may also be a conditional use permit process. If so, again, it would be heard by the city's hearing examiner. And then other than that, I think one of the early slides showed that there would be provisions for a pedestrian trail to be granted to the city along the western edge of the north parcel mining. And so the city would have some role there to implement that. Right now, the plan is included in the city's open space chapter of the comprehensive plan, but the council might want to make some decisions about funding improvements, limited improvements there in terms of picnic tables, benches, trash cans, those types of passive use appurtenances that might be appropriate there. And then last but not least, there is a process related to the funding for the restoration plan, and there may be some improvements constructed as part of that require maintenance. The city would have some role in the conversation about who bears a responsibility for maintenance, what the maintenance is, and those types of things. So that's a quick summary.
Okay.
And certainly my colleagues at the table can chime in if I've missed anything or.
So, Council Member, I would also add that in adding on to the city's important role in the regulatory process in the green and the blue lines in the mining portions. There'd also be the Department of Ecology and Department of Natural Resources having regulatory oversight on certain specific areas, and on restoration, just in terms of understanding some of the work that we'd need to do. That would certainly include, similarly, Department of Ecology, Department of Fish and Wildlife, as I would read it, and probably the Army Corps of Engineers, just because of it looks like the numbers of things that would probably need to be done. So those are all, along with the city's leadership on regulatory work, things that we commonly do around the state is we work on aquatic resource projects in as much of a collaborative process as we can, so we're efficient across agencies and not duplicate efforts.
So those various agencies, including yourself, that you referred to, is that something that you can spell out now and say, that in this particular line, these agencies will be involved, and in this particular box or decision point, these agencies will be involved? I understand that the city will be the lead agency in the permitting.
There are some things, some of the answer to that question depends on the precise nature of the work that would be called for by the restoration plan. But for example, if there is work that involves discharge of fill or dredging in a wetland, then that's going to require Army Corps of Engineers review under Section 41404 of the Clean Water Act, and Ecology has a role in that permit process as well. And Sally, and then the Fish and Wildlife has a role if there is work within a fish-bearing stream. So if you're talking about the creek, there could be a hydraulic project approval necessary.
What we might be able to do is in a fact sheet be able to answer that question as we would understand generally how these processes work, what agencies would have a role, and what permit or what process is applicable.
Let me sharpen one other point if I can. Well, you mentioned in the restoration plan that there will be a stakeholder process and development of that restoration plan. Did I understand you correctly?
Yes.
Would the city have a role in that?
Yes. The way that the restoration planning process in the settlement, and I'll ask my colleagues to jump in and add into this, is that the notion would be is to have a neutral natural resource organization. It could be South Sound Salmon Enhancement Group, be the convener, and run be a stakeholder gatherer and figure out how to coalesce the energy, the ideas, and the input of the number of parties. Do know that there's been some work on a feasibility study that I think about 6 or 7 months were spent. Some stakeholders were involved in that, not nearly as comprehensive as what this settlement agreement has envisioned. So the city would be a part of that, as all organizations would be. So Tom, Pete, would you add anything to that, or Bob?
I guess I would add that the city definitely has a role in that process, because when you talk about a restoration plan, you have to talk about all the landowners who have property in the watershed, and the city is a major property holder in this watershed. And so from that perspective, there's a real interest in having the city be a part of the dialogue.
One final question, then I'll yield the microphone. Below the blue box up here, where it says pump and pre-mine dewater, is there a decision point below that box? That's not a determinative line, right? I mean, if the modeling doesn't work.
It's not a determinative line. There would be a box, but I would expect that to be more in the permitting arena. So, typically when you have a monitoring and mitigation plan, you'll have a problem identification and contingency response sort of process built into that mitigation plan. And so you'll go along, and as you begin to initiate the process, you're checking to make sure that the data that you're collecting and the observations that you have are within the realm of what you expect. And if it's outside the realm of what you expect, red flag goes up. We have a problem or a potential problem. We need to convene the appropriate people from the regulatory agencies and experts, make sure we understand what's going before we move forward.
So there is a decision point below that box where
there's a decision point, but it's within it's within the permitting process. I would expect, and it's not defined in the settlement agreement.
Again, thank you all for your efforts.
Councilmember Grant?
Yeah, and I echo Councilmember Ehrenreich's appreciation for all the work. I know this has been a huge process and lots of time and energy and effort by many of you and many others. Following up on the problem identification and resolution plan process, I concur with Councilmember Ehrenreich. That was a big thing that jumped out at me in reading the plan, that there's not the specific details of what that looks like. So it's good to hear that that will be included. Following up on Councilmember Ehrenreich's questions, will that include who has the clear responsibility in case things don't move in the direction that we're anticipating, that this process doesn't work? Will that plan include very specific clarity on who will have the responsibility for not only fixing any issues that come up as well as paying for those issues?
Go first. I would, from the city's standpoint, I would expect that the permit conditions are going to contain some detail as to problem identification, mitigation, response, and that will direct who will be responsible for taking those steps and at whose costs. And then it would be up to the agency that issued that particular approval, whether it's the city or the Department of Ecology, Department of Fish and Wildlife, to enforce and insist on those actions if they weren't being taken voluntarily. Anyone else want to chime in?
I would just point out that this, we put a lot of emphasis in this discussion about looking at this particular figure, but in fact the agreement is, 40 pages long, and so this is sort of the cartoon schematic that is trying to explain. And if you look at the agreement, there are a number of places that there's a one big decision square in there or the diamond talks about the 5 different elements in decision making. And there's quite a bit of language in the agreement and quite a bit of discussion about where we would be at a potential meet and confer point and would have to consider this. But the idea was that much of this isn't really determined yet. The process would be unfolding along the way, and we would be identifying some critical discussion points along the way that would inform the process and would represent decision points, opportunities for making a change.
I think the other thing I'd like to point out too is when you look at that pump test pre-mine dewatering, we're looking at a situation where we've installed water wells. We're pumping water from them to draw down the water and test what the aquifer is going to do and to gather information. At that point, if there's a problem that cannot be resolved, or there's a potential that at that point, that late point in the process, conditions are such that the dewatering can't go forward, because we can't get the conditions as anticipated or that are needed. And then, provided everything goes correctly with the pump test and all those conditions are within the realm expected, we would go into another phase, which would be kind of a 6-month phase of a larger dewatering process to prepare that first segment of mining for dewatering. Now that's a pretty significant amount of time to be able to both observe what's happening to the aquifer and collect information and present it to other experts and agencies and understand what's going on. And even at the end of that 6-month process, if conditions aren't correct, and I would expect there will be a number of conditions and provisions in the agreement, in the mitigation plan and permits that require that to be considered and specify what those parameters are going to be, that if conditions are not as expected, you can turn the pumps off. The water would return back to the back to its condition as it is today, relatively rapidly.
Thanks. Just one more question. In looking at all the time and energy that's gone into this, and one of the big priorities for the council is restoring the flow to the creek. And I just wonder if any of you have basically could provide some context to the valuation of this. I mean, when you look at the permitting and the restoration work and the monitoring, talk a little bit about the value from each of your perspectives, if you could, of how much time and energy has gone into this and how much time and energy will continue to go into this going forward.
Well, I'm honored that you would think I have something to say about this. That's a tough question. I think that we did put, from the Environmental Caucus perspective, I'll tell you my personal concern is that we would agree to something that would end up being a real negative in the long run and would really, first of all, preclude a real restoration in the watershed. That's really what our interest is, and so we want to see that it's a plan that's going to work. We also don't want to see the city water supply compromised. I personally don't want to be burned in effigy by fans of the Environmental Caucus. So I'm very interested in seeing that we have a good plan. And one of the things I think is unique about this opportunity is that the process that we're putting forward here includes some early discussion of developing a monitoring plan. Pete earlier mentioned that there were already a number of groundwater parameters that have been studied and would be studied going forward. There are also surface water parameters that we'll build into the restoration plan. So we'll be looking at a number of points around the wetland and in the watershed. And so in terms of the thoroughness of the approach, this is I think a very uniquely conditioned process where we're really able to take a very start with training wheels, easy approach here, see if we can make this work, see if we've got the right conditions. And if everybody agrees that it's lining up, we can keep moving forward. But I think that's fairly unique in this kind of proposed development, to have that kind of balance maintained through the early parts of the process.
Thank you. Councilmember Trotter? Oh, okay.
Did you?
I'm sorry, I saw your name go off the queue and I thought, oh, he's done.
That means I was right there.
Okay, you're still on the hot seat. So keep going.
So I would add on to what Tom talked about is that the Environmental Caucus was able to bring in a University of Washington science specialist who does a lot of work on restoration, Dr. Derek Booth, and he brought a lot into the process. You know, in some ways, coming into these negotiations took a while to help him understand the context, but his then understanding the context and then what he could, as I observed, provide for that input as somewhat as an outside expert on restoration was very valuable. Dr. Booth is someone that at the Department of Ecology in our watershed restoration work we look to as one of the state's experts, if not national experts. So just his credentials were something that for myself, I felt very positive that he was a part of our process. I don't pretend to really understand a lot of the science behind restoration, but I believe that there are people that do, and he seems to have a lot of the right credibility and ideas, and a lot of good questions that he brought and had us wrestle with.
And I'd like to talk a little bit about the value. Just certainly we've done a lot of the spending related to this, getting some of this information. You know, it's a unique situation where you get to basically start a process of designing a project and you have 10 years worth of data that's been collected in a very systematic, appropriate way, that you've already done substantial amount of groundwater and surface water modeling. So we have a lot of information that is current and up to date. We've continued to collect information on groundwater elevations and surface water flow conditions in the creek. We monitor vegetation in order to have a baseline. And that gives us a couple things. It gives us a really good understanding of what's going on in the current creek and the conditions that are currently going on in the system, the changes that are naturally happening over time in the system. And it helps us design a better restoration plan, have better confidence that a restoration plan is going to work or not going to work. if that's what it comes to, but we will have a good understanding of what the restoration is capable of doing. And it also gives us something very valuable when we go forward in the process with our monitoring to compare back to, because we have what statisticians call a lot of statistical power to compare future conditions to past conditions, all those data points. So it would be very hard to do a similar project without all this information that's essentially already here to be used, and there would be continual monitoring after the restoration was implemented as part of the ongoing monitoring required for mining operations that would also contribute considerable value to the whole restoration process here.
Any other responses to Councilmember Graham? Councilmember Graham, does that fit the bill? Do you have a follow-up? Okay, Councilmember Trotter?
Okay, we've all gotten a lot of emails and comments from the public already, and I have some, questions and that kind of, based on things that people have told me. But since you've been talking about your experts and the scientists that you have been working with, that you did this feasibility study with, I'll throw out this question first. We've heard comments from members of the community and interested parties in this project that the scientists from Aspect or is that the name of your, and Parametrics and the Department of Ecology have falsified their information and provided slanted interpretations of the data to promote your project because you're paying the bills. Now, I find that difficult to believe, coming from a profession that is a public servant, but can you guys speak to the trustworthiness of all the data that you guys have basing all of this information on?
I'll speak to that.
Thank you.
If you bring me information and can prove to me that there's a consultant who has altered data, fabricated data, slanted data in a way that's, unreasonable, inappropriate, and given information to me that I can't rely on, they will not work for us again.
Anybody else?
And what I would say from the Department of Ecology is that we start with a premise in our work that we rely that people that we serve and who we regulate are honest in the first place. And when we require permit applications, we don't go out and do the research and the science behind water discharge, air discharge, hazardous waste cleanup. We rely on who is coming to us to seek permissions to do certain actions that they need a permit from us. So, we commonly use information that's brought to us and delivered to us from nonprofits, from private companies, from governments for your wastewater treatment plants, your stormwater programs. I have to say, when we have questions, and we often do, we ask them and we dig in, we ask for methodologies, we ask for verification, we ask for additional sampling. If there's a reason that we doubt information that's provided to us, it's our responsibility, and we take it very seriously to keep the trust of the people of the state, that we work with accurate and reliable data.
Thank you.
I guess I would also add that, the Environmental Caucus, I think by its nature, represents some skepticism about some of the science that's offered sometimes on projects. And so we were very careful to select Dr. Booth as someone to help us evaluate and ask the good questions about what we were seeing in the process. And I would relay that he had positive things to say about the work that had been done previously in terms of analysis. He said he believes that there was a lot of sound data that was useful to the process. And he was also the one that helped us early on in the process look and say, a big part of the issue here is losing a lot of the water from Sequatchie Creek down the diversion canal, and that there's if you can get that water back into the system, there's a real possibility of a real positive outcome from this. And it was sort of his initial analysis of the water balance in the system that suggested to us there was potential for a negotiated settlement. So I think from our perspective, we're pretty confident that we have a very honest review of the data that's coming forward and would come forward in this process.
Were you going to say something, Bob?
Yeah, just to add on, this is from a process perspective. It's very easy during the legislative process where people are commenting to the city council or to another legislative body for someone to make a charge that data is slanted or fabricated, and they don't have to back it up. But the process that's built into this agreement for review of the permits is a quasi-judicial land use review process. For the city's process alone, but I think I can speak from some experience with the Ecology and Corps of Engineers permit process. Those permit decisions are made by experts in the field. Hearing examiner is a person with legal training and formal land use training. And if someone believes that the data supporting the application is incorrect or slanted or misleading, they have an opportunity to appeal, to come in and cross-examine the experts supporting the project, and to put on their own expert testimony that says, no, this is what the correct data is, or are, sorry, pardon me, if they have an expert who can do that. They need, at that point, to back up the charge. And this process allows many opportunities for that to happen, or not only in the SEPA process, but in the permit processes for both the mining projects and the restoration plan. So there are opportunities, if people have those concerns, for them to test those suppositions and to bring in other evidence if they have some.
And I'd like to add on after I've calmed down a little bit, because this is such an important issue for me. You know, in my role, a big part of understanding what's going to happen really comes down to the company's liability. And if we have a mischaracterization of the work that we're planning to do or a process that we're going into, you know, it can be a very costly and difficult situation. Now, that said, I think it's also important to understand that science is one of these things where sometimes you have a lot of information, sometimes you have a really good understanding, and sometimes you have a really good suspicion about what's going on, and you may either need more data, and you have to kind of tailor the amount of information that you have and the amount of certainty that you have with what you know and kind of how you're applying that information. And it's important for scientists to express their certainty when they present their data. One of the things that I think is really reassuring to me in this process is the fact that, for example, our groundwater modeling work has been reviewed. Some of the groundwater model was originally prepared by CH2M Hill, was taken by Aspect and worked over and developed very hard with substantially more information and updated substantially. Reviewed by Pacific Groundwater Group, who worked on the EIS on behalf of the city as a third party. Reviewed by Parametrics as part of the application for the conditional use permit as a third party employed by the city. And the groundwater modeling work and all this has been reviewed by persons working on behalf of JBLM, including consultants like Northwest Hydraulics and Battelle, all very, very reputable people with lots of experience, years of experience looking at this kind of information, and they all had confidence in the work that's been done. And so I think it's very assuring to have that.
Thank you.
Councilmember Trotter, I would be remiss if I didn't also say that at the Department of Ecology, we often are challenged and ask lots of questions, and that's what we're there to receive, because although we do our best with the technical staff that we have to do our job, there's times where information is brought to us that helps us do a better job. So we welcome that. I also need to acknowledge that constructive criticism and dialogue is something that is a part of our regular job. And I should also perhaps finish with that we have a number of appeals that are made with the permits and the decisions we make. And, you know, we stand up to a lot of legal challenges, and we win far more than we are found to not have done the work. So, you know, we do need additional scrutiny. We welcome that in our processes, and we have attorneys who have to do a lot of work to when things can't be resolved at the sort of commenting period when it elevates to the court. So there's certainly the opportunities there that we see our decisions debated and appealed, and you know we do our best to carry out the laws of the state in the ways that we interpret the laws and think are the proper course for interpreting those laws.
Thank you. I believe that you guys have all done a lot of serious work, and that you've employed a lot of very admirable people to do the science for you, and I am certainly not a scientist, so I defer to their judgment. I would have been remiss had I not brought up the concerns of some of our citizens about the value and the validity of the data that you're working from. Most of the rest of the concerns that I hear are all about dewatering the aquifer and the issues concerned with that. Yet because the decision that we're making about this agreement doesn't really say yes or no to dewatering the aquifer, I'm going to defer on all of those questions, because that's not really what this question is about. This question is about whether or not we agree to this agreement, and the question about dewatering the aquifer or not is a permitting question. So I have questions, but they aren't for this venue. So thank you.
Well, I come from a little different perspective. In the sense, I think it's important for us to identify some of the features within that permitting process that ultimately could influence agreement or disagreement. I realize this is a very general agreement in its nature, and it's a start of a process, and thank you for initiating this. And we're getting a lot of information. I would like to get back to what Council Member Trotter mentioned, having to do with the authenticity of data and of personnel involved. I'm a great advocate of peer review, and that means purposely going out of the established circle and seeking opinions, concerns from other experts in other areas of the country. I'm concerned about the amount of scientific review of the literature within these two areas. One, the dewatering aspect, and the other one is the restoration aspect. I appreciate the involvement of the University of Washington. Also talk to the people over at WSU as well, okay? As far as the dewatering is concerned, here again, the modeling, the scientific review of alternatives, I do like research, and I do like to receive data. So Pete, provide me that data broad range. Along with this, Tom, I think the city has a role also in determining the checks and balances having to do with monitoring. From what I picked up from your conversation, it sounds like the city's being excluded, and it's all within the realm of the environmental caucus. I'm a little concerned there. The city does have part there, and I'd like to see that kind of defined. We have an excellent consulting engineer company on contract, Gray and Osborne. And I have not heard nor seen their involvement in this at all. They're the ones that we turn to for our water supply, to give us analysis of the future and what's going to be happening. If this happens, then this could happen. Before I vote yay or nay, hopefully, Madam Mayor, we would be able to have some input from our consulting engineers in order to provide oversight, if nothing else, to protect. To what extent the city has been aggressive in working with the negotiators has been questioned. I have faith that our lawyer and city administrator represented the city quite well. Now we're getting into the technical aspects, and we're going to be relying upon Bill Kingman and his staff and his diligent study of this proposal to guide us, to give us input as we move forward to final agreement or disagreement. So those are the primary two areas that kind of hit me hard. Number one is expanding the scientific knowledge that is used to have the basis of the dewatering, the scientific knowledge, peer review, and all this having to do with restoration. Make sure that it is on sound, firm research that has been proven in other communities. And then the involvement in that monitoring system. I don't know quite the detail. I looked in the agreement there and I'm just not comfortable it's nailed down to the point where the city is going to definitely, together with you in a collaborative, the environmental caucus, have that. I appreciate the state departments. You said that the Department of Natural Resources, Department of Ecology, the Corps of Engineers, and you have state agencies. That's well and good. We want to be an integral part of that too. Thank you.
Madam Mayor?
Before we...
I'm sorry, if I could just respond quickly to what, I won't respond to the scientific points, but on the monitoring, the way the conversation evolved on that, the development of the monitoring plan during the negotiations was that the city had some concern that as one of the regulatory agencies that it shouldn't be also a proponent in developing the plan. However, as a regulatory agency, the city needed to and should have authority to approve the monitoring plan. And so there is a provision, it's paragraph 7.2 of the agreement that says dewatering of the south parcel will not occur prior to the city's approval as part of the permitting process of a monitoring plan to monitor stream flows, marsh levels, and groundwater levels. And so, then it goes on to say it'll be prepared pursuant to other sections which are primarily speaking to how the Environmental Caucus and CalPortland will develop the plan, but it will then come to the city for review and approval. And we were on the same wavelength as you were with that on that point.
Staff, I would like you to add a question to the frequently asked questions. We currently have 10 from the cities that we're tracking, so we're going to add 11th one. And we need to address how Gray and Osborne has been involved in this process. And then also talk about, do they have a hydrologist on staff and what that oversight would look like should we want to ask them to do more. Okay? Any other follow-up comments, panel, to Councilmember Westman? I understand there's two other council comments, so I'm following up on Councilmember Westman.
Certainly, I'd like the opportunity to follow up to Councilmember Westman, if I could. Councilmember Westman, we identified with regard to the groundwater modeling work and surface water modeling work, PGG parametrics, Battelle, JBLM, Scientist Northwest Hydraulics. That's 4 really well-known senior level groundwater hydrologists, and you have to be a little bit careful when you go far afield to find input from experts, because it is important to have people who have experience, knowledge of the local geology and the local conditions in this area, as well as the agency review that's been conducted by Ecology and others. And I also want to point out that although Gray and Osborne didn't do the review, Parametrics was hired by the city, reimbursed by CalPortland, specifically to provide third-party review of all the work that was done under the Squalcha Creek EIS, and that went into the application. And so I think that's a real good source of information that should help give you some good assurance as to, you know, the quality of work that was done there and the level of review.
We have 2 council members in the queue, and before we go to them, I want to just offer up, if someone has a burning question, staff's going to come around again with index cards. Let's keep those coming in. Councilmember Coffey?
Thank you. I want to also thank all of you for the amount of time that you have put into this. I did attend the feasibility study meetings that were open to the public back, I believe, in the fall of '09. Was that correct? Very, very interesting. Bob, you addressed the first question I was going to ask, and whether or not dewatering was addressed in the settlement agreement, and you have said that it is addressed in the settlement agreement. I guess I'm going to go a little bit in a different direction, and this probably I would think would be directed towards the attorneys. What happens if the city does not accept the settlement agreement? And really, right, and
Mr. Chestnut up.
Right, I would really like to hear from the environmental caucus attorney. Is the microphone at the table there? Is it working? The one right there? Yeah, it's working.
Perhaps
okay, there's another
you
one.
could reintroduce yourself. Thank you.
I'm Brian Chestnut. I'm out of a law firm in Seattle, and I represent the Environmental Caucus. And I've been involved since the late summer of 2010. I think the answer is pretty simple. I think that in order to have an agreement, we need all the parties to agree. So if the city doesn't agree, the agreement that is before you will have no effect. If the city didn't agree, we would suspect the city might have some reasons for not agreeing, and we would consider those, and there may be some changes that could be made. And if the city didn't want to participate, I'm not quite sure what we would do. But those are my...
Yeah, no, I would... I'm Steve Bruce, CalPortland, and I agree. I think that's correct. I mean, the agreement has been signed by all of the parties other than the city, but the agreement is not effective until it's signed by all parties, and that means until the city signs it, it's not an effective agreement. So if the city were to decline to sign it, I think we would, to use our favorite term, meet and confer and decide how we wanted to proceed from there.
Is there a current conditional use permit in with the city right now?
There were applications that were submitted and that have not been, I don't think, formally withdrawn. I'm looking at Pete to see if he, sure, but those applications would need to be revised substantially in light of the new mining plan that the parties are contemplating at this point. The permit applications that were submitted previously had to do with the North Squalcha Creek alternative, and that's not an alternative that's currently on the table.
Does CalPortland have the opportunity to amend that conditional use permit and move forward with that?
I don't know what, I mean, I suppose if the settlement agreement is effective, that is to say, if it's signed by the city, then that particular alternative would not be able to move forward.
Right, I understand that, but if the city says no,
Correct. Yes.
does CalPortland have the opportunity to move forward with the permit that is on file with the city at currently?
Yeah.
So if we don't sign it, that permit is still there, and so there's the possibility of a gravel mining expansion permit being dealt with by the city.
Yeah.
And would there be restoration done otherwise, other than this agreement?
Well, maybe I'll leave it to Pete. Under that permit application, as opposed to the restoration plan with the 5 elements that we've been discussing and that are identified in the settlement agreement, the mitigation approach with those permits is the creation of North Ecology Creek. So it's a very different sort of approach toward mitigation. Yeah.
Okay, so I guess what I'm trying to get at is if the city does not sign the settlement agreement, the city does not get a restoration plan of the Ecology Creek and the Edmonds Marsh.
I'm gonna leave that one to Pete.
You know, I don't. That's a possibility, I suppose, but you know, in respect to the other parties who've already signed the agreement, our first step would be to, in my opinion anyway, I think our first step would be to do as what Mr. Roos said, is go back and meet and confer and consider all the various different alternatives and what could be the best approach. You know, we'd like to have a process and a plan going forward that you know, that the majority of people can support. And that would be our goal. And so we'd meet and confer and try to find that. And if, you know, if that was not a possibility, I just can't say what we would do. We would certainly have to consider pursuing the other option, but I don't know that that's what we would do.
Okay, thank you. Who would like to speak to JBLM's part in this? You mentioned them twice here, JBLM acknowledgement, and then you also mentioned JBLM consent.
Well, I would maybe speak a little bit to that. When we were envisioning a watershed restoration throughout the Sequatchie Basin, a big part of the issue for Sequatchie Creek and Edmonds Marsh is the diversion canal that is operated by JBLM, and part of the restoration plan would envision reconfiguring that or reconfiguring other elements downstream of that so that the water could again flow down the natural stream channel. And so they're very much need to be a part of the process, but they're a federal installation operating under a completely in some ways unique set of circumstances as an organization, and they have to be very careful to not engage in this, what is in fact, you know, this settlement agreement is essentially something other than the litigation that might have resulted if we hadn't been able to come to some agreement through a mediation process. They don't want to get involved in that part of it. They have come to us and talked to us about their interest in seeing a restoration plan move forward. They don't want to be a part of the political legal dispute that's going on, but they have indicated that they would be willing to support a plan that was being put forward in a cooperative manner. And so we spent quite a bit of time. They came and spoke to us several times during the process, and we spent quite a bit of time talking to them about precisely what their process looked like and what it meant to come up with. There's two parts here. The first, Diamond talks about the JBLM acknowledgement. That basically would be the point at which we would talk to them about a restoration plan, and they would say, yeah, we think we can be on board with that. And then later on, after we went through some permitting process, they would give us potentially consent to move forward with a project, to do project elements that were on the Fort property. And so I would, I guess in my professional life, I spent some time working with Joint Base Lewis McChord, and I know that as an organization, they are very interested in restoration projects. They see Sequatchie Creek Basin as a place where there's some real potential for restoration project, but they recognize that they can't do that alone. They only have a part of the watershed. They need to work cooperatively with the city, and here we've introduced a host of other organizations with an interest in the matter. And so they've been very careful about defining what their roles and what their checkpoints would be in the process. And we very carefully crafted some language in the agreement around what their decision-making process would be and when they would be able to sign on to the agreement or sign on to the process.
What kind of assurances did this group have to give JBLM? You know, that in order for them to start with the restoration, because the water starts on Fort Lewis.
If I could maybe jump in from a process standpoint, and Steve and Brian can supplement, because the three of us and some others in the group participated in conversations with the JBLM environmental attorney, who emphasized that from a process standpoint, there were essentially two things that had to happen as far as JBLM was concerned. First of all, that they have their own set of federal environmental regulations under the National Environmental Policy Act that they have to follow before they can make a decision about whether to approve and participate in the restoration plan or not. And so that's similar in some respects to the SEPA process, but not identical. And they made it, their attorney made it very clear they couldn't even make a decision until they had gone through that process and developed the appropriate record. And so that's why the agreement in this graphic refer to acknowledgement that would be an informal, yeah, we've reviewed it, we kind of like the idea, but we're not saying yes. We can't say yes or consent until we've gone through this environmental process. And then at the appropriate levels at JBLM, since some might say the military is somewhat hierarchical, that the folks in charge of their property aspects of the base could then make a decision, yes, not just the folks associated with the base who are involved in environmental issues, but that from an operational standpoint, that they were willing to and could agree to make the changes to the weir and the other things that are contemplated by the restoration plan. So both of those process pieces were emphasized in the calls that I participated in as prerequisites before JBLM could say yes to what's out here. And Steve and Brian, you could supplement or?
I agree with what's been said. I would just make it, in my mind, it's fairly simple. You know, we can't have a restoration plan that's successful without JBLM's involvement as the property owner. We said to them that we wanted them to be involved at the beginning of the process as a part of that stakeholder group we were talking about, and they were fine with that. We said to them, when can you tell us 100% go ahead on our property, on JBLM property? And they said, what Bob referred to, in short, we need permits. If you guys get permits in hand for the work, then we can give you the seal of approval. So that means that there's going to be a number of years potentially before JBLM actually says, okay, go ahead, you can do it. Because there's going to be the stakeholder group preparing the restoration plan, the finalization of the restoration plan, the process to get permits for the restoration plan, and then JBLM consent. The JBLM acknowledgement is an earlier stage where we're getting an informal approval saying that they looked at the plan and it looks okay. but they're not going to actually authorize the work. It's only after we get permits for the restoration plan and they consent to that.
Okay,
And that's actually somewhat the reverse of our typical permit process,
Right.
where the consent of the landowner is the first thing that
Right.
you get in the permit process. Theirs comes at the end.
So does CalPortland start, the pump testing and the that sort of thing? Do you start that before, or is it like coincide, or how does you get your permits, and then you said something about a federal process that JBLM has to go through. So then do we have to give them the time after CalPortland should get their permits? Then JBLM has to take their time to go through their federal process. So it basically would be holding up the whole timeline?
Yeah, I would suspect that would be the case. I mean, the restoration plan, everything is going to need to be in place for the restoration plan to work in order for the mining to go forward. And so, as you can see, I mean, we're talking about a process that has a lot of steps and a lot of pieces that have to come together. So, it's going to require a lot of coordination among all these parties in order to make not only the restoration happen, but, the actual opportunity for CalPortland to mine happens at the very end. So,
if I might say something, maybe a little bit different take on that. We're imagining the JBLM acknowledgement to happen at the completion of the restoration planning effort, which would happen in the first year and a half. And then after that, there would be a restoration plan permitting process. In both those, we would expect to see some involvement of JBLM. They indicated they would be willing to be involved as stakeholders to that process. And so, and in fact, you can't really move the permitting process forward without their engagement in that in a lot of ways. And so really the hope is that we get to that point, year 5, where we're looking for JBLM consent. They're pretty much on board at that point to go to their garrison commander and say, look, here's the permit, here's the plan, we've looked this over, we understand what the impacts are going to be to our organization, we've got a path figured out for what the costs, what the effort is going to mean to us. And hopefully, they indicated that once that was at that point, they thought they could make a decision fairly quickly and move forward with it. That was what I understood them to say. But that's at the end of a 5-year process. So this really is a process that has a lot of concurrently moving parts and has to all come together in a highly orchestrated manner at the end to be successful.
Okay, I think your attorney would like to say something.
Yeah, one of the major themes of the settlement agreement, without getting into details, is that we wanted to ensure, and CalPortland was willing to go along with this, that the restoration plan, that the South Parcel mining that they contemplate for the future, the new South Parcel mining site, would only happen under our settlement agreement if the restoration plan had all of the approvals necessary and all the funding that we negotiate in place, those kinds of things. So basically, we want them to coincide, the restoration plan and the South Parcel mining. And JBLM plays a big role in that because until they give us their approval, then we won't have a restoration plan. And therefore, we won't have South Parcel mining under the settlement agreement. If something goes poor, for example, JBLM doesn't authorize the restoration plan, then we are in a meet and confer. And there, we don't know what would happen exactly at that point, but it would not be under the settlement agreement anymore unless we agree to go forward under the settlement agreement at that point.
Thank you. Sally?
Thank you, Council Member Coffey. That's a great question that prompts that as we create more explanations of process, how that federal and state land nexus works. I think we can do a better job of showing how that works. So that's point one, is that you could imagine, you know, the next slide, and then the next slide we could, like the question that was asked earlier about all the regulatory processes. Another slide could be, what about with Joint Base Lewis-McChord? And there may be some others, so that's a good prompt for us to try and be able to describe and forecast how that could work in a sequence. The second point I would make is that the permitting that would go on in the lands that the city DuPont has that are adjacent to the fort, a lot of the evaluations that will be done through environmental review under the State Environmental Policy Act may answer some of the very same questions under the National Environmental Policy Act. So we would hopefully design that so that that work doesn't have to be duplicated, so that it would be a little bit more streamlined, or quite a bit more streamlined. And then with the Army Corps of Engineers and Ecology, having Federal Clean Water Act permits on both, I would anticipate the permit writers for those would be the same. So although there would be different permits issued for whoever is the permit holder for the DuPont area restoration, would write the same permit that would be for the federal land. So there's some places where we can do a better job of explaining how there is some extra steps, but how there is some linkages. And I think that's important for us to think about how we do a better job on that.
Right, because, you know, without JBLM, this restoration plan does not work. You know, the city, you know, you can't be digging a ditch out there and draining Edmonds Marsh if you don't have water coming in from JBLM.
Exactly right. That's right.
So, I did want a point of clarification or a comment for Councilmember Westman. Dominic Miller was here at the town hall meeting from Gray and Osborne, taking notes, and so and he has been very involved in our water master plan, and that will be coming forward pretty soon too. I guess I will. I'm done for right now. Yeah, thank you.
Councilmember Hills.
Thank you. I realize that the farther out one goes on the time scale, out that 7 years, that the more sketchy everything becomes. But I've heard this come up a couple times, and I do get emails from people. Pete, when you spoke on the 30th, you referenced the fact when the pumps are turned off. And then tonight I heard Sally say, some water into Edmonds Marsh, some, but not all. That was the quote. And so my question really is kind of a technical question. What happens when you turn the pumps off? And let me fill you in a little bit. I come from back east where they did an awful lot of mining to take out granite, and they've ended up with water infiltrating, if that's the right word, flowing in and creating a lake. I also then see myself questioning, what about the saltwater flow? There's a possibility, I would expect, for some flow back into the area. We could end up with, as one person said, an attractive nuisance, i.e. a lake that we don't want, and we could end up with saltwater infiltration. So those kind of questions I'm getting from people, and at the same time, when you turn off the pumps, what's going to happen to the water? You've been pumping it out, some of it to Edmonds Marsh, and I realize that we're talking out 7 years, but I'm wondering what happens. Can you give me just a hint?
Of course, I'm happy to give you just a hint. So in order to be able to mine the material in the south parcel, we need to intercept the groundwater as it's flowing into those south parcel gravels and dry it out. So there would be basically an iterative process where we would install a set of wells, pump water from a segment of material that was preparing to be mined, mine that material, move on to the next segment of material to be mined, install wells for that segment. And so as we advance the mining, we advance the wells, and as we complete the mining, we would turn wells off and allow that water to seep into the mine, basically expressed as springs flowing into the mine. The settlement agreement envisions a portion of the water being pumped from those groundwater wells. Because we're pumping the water, it seemed to make sense to make some of that water available to go to Edmund Marsh and basically provide flow to the creek at the beginning of the process so that those benefits could be realized right away. The agreement says up to 5 cubic feet per second. It could be less than that. That has to be determined based on the restoration plan, based on what's appropriate, a number of things that would be, decided in that 7-year period. But that's what's envisioned, and then the balance of that water would go into the mine, into the deeper gravels, and be infiltrated. And so I would like to ask Lori Herman, who's done a lot of work on the planning for the dewatering and can speak much more specifically to what would happen as far as with the wells, and has much more experience with mining and dewatering, to explain this and the saltwater infiltration issue a little bit more clearly.
Lori, can you please come forward, introduce yourself at the microphone at the podium? Thank you.
Hi, I'm Lori Herman, and I'm a hydrogeologist. I'm state licensed and a national groundwater professional. I have mostly studied the North Sequatchie Creek alternative because that's where we collected our data and did a lot of our analysis. And now we're talking about a new alternative, and we have looked at how we can do that through the feasibility study. I guess your question is, where's all that water going to go? I wonder if I need a picture for this, but basically, the wells will go in and they'll form like a dewatering barrier. Yeah, maybe we could go to the cross section.
You're doing a great job at being Vanna and the hand puppets.
Yeah, I didn't expect this kind of a question.
Oh, well, here, I don't even necessarily need the answer tonight.
Yeah.
But I would like the answer if I could get an answer, but we're not going to have all the pros here maybe the next time, but I would like maybe a written answer which satisfies.
How this works? Well, I think I can answer it.
Okay.
Okay. So this is where they're proposing to mine, like right in this area, west of the dewatering wells. So the dewatering wells would go in on the east side of the area proposed to mine, and then they would pump. We have estimates of 7 to 10 CFS, and some of that water would be able to go up to Edmonds Marsh, and it would create this drawdown cone that we've drawn here. And when the wells, as soon as we can, we would like to turn the wells off. And originally we thought this because we were going to try to build this new creek, this. So in this case, I think what we would do is we would grade the bottom of this mine. It would be like that. The first portion of the mine would be like a channel kind of coming through here, and we would grade it like a stream and move that water down into a pond that we would develop down here. Some of these areas would be future wetlands, but we have an unsaturated zone of 20 feet or so, and a lot of this mine, in some of the newer mines in particular, we would make sure that they were left with 20 feet or 10 feet of unsaturated gravel, so that water would then infiltrate and go out to Puget Sound. So there would be no change in the amount of flow that's currently going there, because it would be the same water that's going there now from a quantity standpoint. So this is the Vashon Aquifer. This is the water table surface. As we get towards Edmund Marsh and Sequatchie Lake, you can see that the groundwater and the surface water level are pretty close to each other because they're in hydraulic connection. Very interesting feature from a hydrogeologist standpoint occurs in the mine, and that is that this aquitard is absent in a portion of the mine, pretty much near the boundary of where the existing mine is versus where the south parcel is. And so that groundwater right now flows from an elevation of 190 feet down to about 20 feet. It's like an underground waterfall, but it's all below ground. We can't see it. It's very interesting from a hydrogeologic standpoint. And so that water would be just essentially that kind of waterfall would end up occurring right here. And we would get springs out, and because this is going to be mined out and a channel made here in these Olympia beds, which are low permeability, there would be it would need to grade and flow into a feature down in here that would be a pond or a wetland, and then it would flow into the water table and out to Puget Sound. Does that make sense? So because the amount of flow that's coming through now will be the same as in the future, there isn't going to be any issue with regard to saltwater intrusion.
Jim, that's a great question. I mean, Councilmember Hills, that's a wonderful question. Staff, let's add that to the FAQs. Department of Ecology, if we could track that. I know I've heard that same question phrased in many different manners, so thank you for bringing that up. Councilmember Hills, did you have a follow-up?
Oh, no, I'm done now. Thank you.
All right. Other council comments before we dive into the comments that we've received from the public? Okay. We're going to go over the questions that we've received, and we'll let the panel address those. Should there be additional questions that come up, you'll have more opportunities to get those questions logged and to get responses to those. Many ways, either send them straight to the city clerk, straight to City Hall, and there'll be a link on the front page of our website where you can get that. So the intent is we want to hear from you. We want to get every question addressed. So Ms. Masco?
Sorry, I'm trying to sort through the questions to try and somehow logically lump them together, but in some cases that makes sense and some it doesn't. So we'll just go right through them here. First question is, when can a citizen review a copy of the agreement itself and not just a PowerPoint summary? And the answer to that is it is already available on the city's website. It's also available on CalPortland's website, and I believe the Department of Ecology website in its entirety. So there is a section, a page that we've developed on the front page that then goes into the page with all of the different links and the FAQs and the schedules, and we'll have a link to the town hall meeting on that page as well. So the settlement agreement is already available on the website in its entirety. And I submitted questions at the last meeting. It was stated at that time they would be posted on the web and answered. When will that occur? Be specific. And the city's questions that were asked at the town hall meeting, there is an FAQ sheet. It is available on the website now. There's copies in the foyer out here. As for the rest of the questions that are being developed by the rest of the panel, hopefully those will be available soon, and those will also be available on the city website, but they're not quite done yet. Okay, please elaborate on the city's involvement and participation in negotiations. Who attended, how many meetings were missed, and what specifically did the representative negotiate on behalf of the citizens? Be specific. That question is covered in the town hall meetings, the town hall FAQs from the city, and the city was represented at all of the negotiation meetings. The city was represented by a variety of parties over the course of the negotiations, including Mayor Tamara Jenkins, Bill McDonald, former city administrator, Don Masco, the current city administrator, Bill Kingman, our planning manager, Steve Victor, our prior city attorney, and Bob Sturbank, our current city attorney. As you can tell, there's been some staffing changes over the course of this lengthy negotiation process. The primary representatives for the past 6 months have been our city attorney and our planning manager. City representatives negotiated on behalf of the city, not individual citizens, and protected the public review process. They also obtained a guarantee of an easement for a public trail along the western portion of the north parcel. Okay. What options can CalPortland pursue if and when the process comes to a no position? Years 2 and 6 on the handout. meet and confer as listed. Are there any other additional steps that the parties could do beyond the meet and confer? And I believe we discussed that question already. Was that sufficiently answered? Yes, no? Do we want to review the answer to that again? I'm sorry, I believe this was your question.
I'm Darrell Reek, 1798 Jensen Avenue, author of the question. No, the answers that have been given so far don't specifically speak to the question that I'm asking. I would like to know if there are legal recourses available to CalPortland or other options other than just sitting at the table and negotiating.
Thank you for the clarification. Pete or Steve, would you like to?
Yeah, if permits for the north parcel are denied, then CalPortland could certainly appeal that denial. If permits for the south parcel are denied, then CalPortland could certainly appeal that denial. And likewise, if permits for either parcel are granted, opponents would have an opportunity to appeal. Because as we've tried to stress throughout the presentation, the regulatory process is not changed by the settlement agreement. So to the extent that the regulatory process allows for those kinds of appeals, those processes continue.
What does the city, what does the city receive in the way of profits from the gravel CalPortland is pulling out of the ground? Bob, I believe this might be a city. It would probably be a question for the finance director, you're correct, and there's a lot of that information that is proprietary. We can't release a lot of information about a specific company. We're prohibited by state law. So that would be a difficult one to answer, whoever asked that question. I apologize.
That's a question that we have received many times in the past 8 years that I'm aware of. Let's put that on the FAQs and just state very clearly a response to that, please.
Right. And what Ms. Masco is referring to is that there's a state statute that governs the Department of Revenue and other persons that prohibits the disclosure of tax returns or tax information where that tax information would specifically identify a taxpayer, and it refers to returns that are filed that relate to payment of retail sales tax or other business and occupation type taxes.
But but I don't think it prohibits listing the taxes that the entity is subject to. And for instance, the entity is subject to B&O taxes. That's general knowledge, and pays B&O taxes. Outside of that, I don't know. I mean,
right. But if the person, for instance, wanted us to say how much in property tax,
can't say the dollar amount.
Correct.
But they are subject to B&O taxes, and they are subject to property taxes, and maybe some other tax I don't know about. But that's pretty much it, I think.
And I, as the biologist for CalPortland, will step way out on the limb and say the limited amount that I know about taxes, and that is I know that we pay a considerable B&O tax, we pay a considerable property tax, and we pay a considerable utility tax. We're probably the largest utility user in the city, which is, I think, your second highest source of revenue. I don't know specific dollar amounts.
Property taxes are public information, and you can, anybody who wants to know that can go on the assessor's website and find that information.
Depicted on the north parcel easement, there is a wedge of property connecting Puget Sound and the mine. What is that area's purpose?
That piece of property is not owned by CalPortland, so that's the reason that little piece is carved out. That's railroad property, and we don't have any control over that.
Okay, will that pedestrian trail be able to connect to the north of that wedge and the loading dock towards Stillicum to meet regional objectives of Parks Master Plan?
I believe there's space around the end of that, at the end of that property where it could connect, yes.
And also on the map of the north parcel, it shows 3 parts of the 45 acres set aside. Why the gaps? And the question may have just been answered. And should they not be together to make one continuous area?
Well, I explained the triangle piece. The piece to the north is where the current conveyor and barge loading dock occurs. And that's the Tatsolos Point Special Management Area that was established under the 94 settlement agreement and those shoreline permits associated with that. And we needed to preserve our right to maintain and take care of that facility.
Thank you. Does the restoration of Sequalchie Creek depend on pumped water? And if yes, then what happens when the mining is done and the pumps are turned off? And I believe part of that question may have been answered a few minutes ago.
That's correct. It wouldn't depend on pumped water for perpetuity, no.
What plan are you talking about in relation to the restoration plan? What plan are you talking about the creek, new mining efforts, and current mining efforts? Each has or will have a restoration plan. This statement is not specific about suspending the restoration plan.
There's a few kinds of plans. The restoration plan for Sequalchie Creek. Then there would also be reclamation plans for each of the mine sites. The reclamation plans are required under the State Surface Mining Act, and that dictates how the property will be left after mining is completed.
What are satisfactory dewatering results? How much drawdown is too much? And how does this plan comply with DuPont Code, which prohibits actions which affect a Class 1 wetland?
At this point, I think it's pretty important to point out that there is no plan. This is an agreement that lays out a process. And while we know a lot about the existing conditions out there, and we have a fair idea what a plan might look like from our analysis of the North Sequalchie Creek project, the new restoration plan has not been developed beyond the 4 or 5 points in the agreement, and the mine plan has not been developed beyond those conditions in the agreement.
During the feasibility study process, CalPortland stated that restoring flows through Edmund Marsh was flawed because it couldn't be touched due to its classification as a Class 1 wetland. What has changed between then and now to allow a restoration plan to be so, I'm not sure, pivotal perhaps on the new agreement? Political?
I think that when we were, I can vaguely remember that point came up in the discussion, and what I think was said. I think that's one of the reasons why some of this discussion ends up being confidential, quite honestly, is that one of the things that we talked about was what needed to be done in the restoration planning, and I think at some point the expression about what could and couldn't be done in Edmund Marsh was really somewhat thinking in advance about the complication of the permitting that was going to be associated with that. It wasn't going to be an easy thing to do. And it wasn't until later in the process that we sort of started describing it in terms of a broader plan that would have its own permitting sequence involved, and that was really integral to being able to do that work. So I don't know that that's even though that might have been said in that discussion of the feasibility study, I don't know that that was intended to reflect anything more than the fact that there was a permitting process that would be required
to be able to assure that the city standards were being met.
And if I can maybe supplement that, part of, as this conversation evolved, part of what became clear is that we will really need to know what the particulars are of the restoration plan when it's designed, to know exactly what the permit process will look like and whether it fits within the code as it's currently drafted, or whether some conversation with the council about code changes would be needed. It may be that the restoration plan works very well based on the changes at Fort Lewis and doesn't require work within the wetland itself. It may be that it requires work within the wetland and that work might meet the definition of an alteration. But the code's definition right now of an alteration that's prohibited is one that adversely affects the functions and values of the wetland. And that's I think a scientific and or biological determination, not just, and doesn't apply to, you know, every molecule of dirt that might be touched. So I think the reason that we're now talking about a restoration plan and not talking specifically about the code is because of the clarity that's going to come as the process continues and the restoration plan's designed. And I guess the last thing to say is my understanding is that there are draft, and Bill, is it the Shoreline Master Program draft that's moving forward right now that has code changes in it?
That's correct, yes.
That will be going forward. So it may be that independent of this agreement and the restoration planning process, that there are code changes that the council considers.
And I would just add, not specific to the negotiations and the discussions that may have occurred at the feasibility study table, but around the state where there are restorations that are requiring permits from federal and state agencies. I can't speak to all the local agencies. That impact of wetlands does occur sometimes in the trying to restore something to its full function. You have to disrupt something that is in its place. And the example, just last week I was being briefed on the Elwha River Restoration Project, and you know, many acres of wetlands are being disturbed as that system is being restored. But in the long range of evaluation, what the Corps of Engineers and the Department of Ecology and their roles look for, and also it's on federal land, so there wasn't a local permitting. What they're looking for is an equivalency in the function that comes back over a time period with adaptive management built in. So, you know, sometimes you do have to do actions that impact important ecological places to bring back restoration and fuller function for the greater vitality of the ecosystem.
Okay, I believe this question has just kind of been answered as part of that, but I'll read it anyway. Does the DMC, DuPont Municipal Code, need to be modified for any mining permit or restoration plan? And I believe what we're hearing is it's a little too soon to tell on either of those. I'm seeing head nods from the panel, so we'll move on. These next couple have to do with dewatering and what is being done to ensure our drinking water quality will remain if dewatering occurs.
Well, you know, the reason this is a difficult question is because I quite frankly don't see the pathway for impact to the water supply from sources in the mine. For one thing, the water supply for DuPont comes from a different aquifer. For another thing, everything that happens in the mine is down gradient or downstream in groundwater speak of the groundwater of the supply of water for the city. And you know, the other thing is we're under pretty strict requirements regarding how we manage our water in our mine sites. At every one of our mine sites, we manage our water. We do a very good job of it. We're regulated by the Department of Ecology under the Sand and Gravel NPDES permit, and you know, I don't expect it to be an issue.
Could I ask a question? Did the Department of Ecology bring their slice of the ground that shows where all the wells are? Did you have that?
That's
or are you
what
trying
we're
to find?
looking
You're
for.
trying to find that? Yeah.
I think it's a separate file.
Yes.
Right, because I think we need to relieve this anxiety that our wells are in a different aquifer than what this is going to impact.
We'll put that slide up when Aaron comes back. I'm not sure where the file is located. Yeah. What recent studies have been conducted to assess endangered and/or threatened species that are present in our wetlands and affected by dewatering, such as plants, birds, amphibians, etc.?
All the work that's been done that I'm aware of in the wetlands in the creek was what's included in the EIS for the North Squalcher Creek project. So those issues would need to be evaluated for under SEPA for the new proposals, both the restoration project and the mining projects.
Thank you. Does the City Council have a vision on what the mine footprint will look like after mining is finished? And what does the city get for all of this? Restoring Edmund Marsh could happen today without CalPortland's presence. Anyone care to take that one?
I'm going to ask the city administrator, could you, and it might even Bill Kingman, could you frame for and help the council understand what is in the current city's guiding documents? The vision?
There's approximately 12 comprehensive plan policies that talk to mining and Sequatchie Village particularly. I'm not going to go through the long list of each comprehensive plan policy, but it is reasonably articulated in that comprehensive plan document as to what Sequatchie Village will be and look like and be developed as part of the master plan for the city of DuPont. In summary, the south half will be developed for manufacturing research park uses, the north half will be developed for residential uses. The extreme north end will be set aside in a very low residential density as a holding zone, residential reserve, because it's not necessary to develop that area to meet our population targets that are given to us by Puget Sound Regional Council and Pierce County. So when everything's said and done, there will be development out there. Thank you.
So, Council, I asked Bill to do that just to give, just to refresh us. It's helpful for me also to hear what's in our current city's guiding documents. Can you please read the question again?
Certainly. Does the City Council have a vision on what the mine footprint will look like after mining is finished? And these may or may not be related, but what does the city get for all of this? And restoring Edmund Marsh could happen today without CalPortland's presence.
Council, is anybody? Yes, Councilmember Westman, then Councilmember Trotter, then Councilmember Graham.
I was informed that the Department of Natural Resources would have some sort of regulatory basis upon what the area would look like at the conclusion of the mining, and that's part of the permitting process. And there might be some other state agencies as well. So it's very difficult, even though we have a comprehensive plan, that's the vision. What ultimately will happen will be what these state agencies together with CalPortland will leave And above all, remember, this is private land. It is not public land. It's not under ownership by DuPont. So the private owner will work with CalPortland and the state in order to fulfill the requirements. That's my understanding.
Council, point of order. Per the council's rules and procedures, should the meeting be going past 10 o'clock, I need a motion to extend the meeting past 10 o'clock. Otherwise, we will ask and direct staff to put the rest of the questions in FAQs, because we still are in a regular council meeting. We still have a few more items. So move to continue. Moved by Councilmember Graham and seconded by Councilmember Coffey. All in favor say aye. Aye. Any opposed? Please let the record show the council meeting continues. The vote is 7-0. Councilmember Trotter?
Okay. Also, I mean, the comp plan tells us what the ultimate use that we have planned for that land is, and as Mr. Westman stated, it is privately owned land. We really cannot tell a landowner what they can build on it, or I mean, we have it zoned for what types of buildings, but ultimately it's the developer and the landowner who has ultimate say about what happens on their property, just like you and I have ultimate say about, you know, what happens on our property. The other thing is the statement that Edmonds Marsh can be restored without CalPortland's money. I want to know where you're getting the money to restore Edmonds Marsh with, and why you haven't come forward with it earlier if you have all this money to give the city to restore this wetland that's in, you know, desperate need of restoration. No, the city does not have the money to do this restoration project. The city does not even have the money to fund an ambulance service in town. So the reality of it is maybe someday, 50, 60, 70, 120 years from now, we might have the money to be able to restore the creek without some outside help. But it's not going to happen, you know, probably in my lifetime without somebody with deep pockets and a desire to do this for the city, to step in and help us. I mean, there are grants out there, but it's going to be a really expensive project. They're throwing $200,000 just at doing the planning for it. You know, and you know, the city does not even have $200,000 to put into a planning for the project, not to mention, you know, all the dirt movers and the beaver relocation and you know, all of the stuff that's going to have to go into really fixing it up. The money is not there from the city, so don't think that the city can do this without the help of some outside agency, be it CalPortland or somebody else. So.
Input on that question? Continue, please.
Looking into the long term, what will the city do with a 550-plus acre hole?
It's not the city's hole. Can you repeat the question?
Looking into the long term, what will the city do with a 550-plus acre hole? I think the answer, yeah, it's not our hole.
If I might add on to the question about the reclamation plan that the Department of Natural Resources has a responsibility to carry out with the landowner. In the settlement agreement in section 3.3 and section 4.4, there's a requirements that the draft reclamation plan be presented to the parties of the agreement in advance of it going to the Department of Natural Resources. So there's a placeholder for ensuring, I mean, anyone can seek input into that reclamation plan. In DNR's process, what this settlement agreement does is gives advance review opportunity.
Yeah, thank you. And just to piggyback on what Sally was saying, the Department of Natural Resources does run a very collaborative, transparent process. They do a lot of scrutiny in the development of their surface mine reclamation plan. And in addition to developing the plan of what it will be restored to, which would be consistent with our comprehensive plan, which was developed by our planning agency and approved by the council, there's also certain bonding requirements. So if things do go awry in the digging of the mine and in the reclamation, that there would be adequate compensation to cover any necessary repairs. And so in addition to it being a public process, there is some assurances with the bonding that the mining aspect would be forced to put up to make sure that any harms that would be created accidentally would be mitigated for.
I've got two questions that I'll just ask back to back because I think they're asking the same question, just in a little bit different way. But since dewatering is being used for restoration, won't a water right be required? And then the other question is, does CalPortland need a water right to dewater the aquifer?
So for restoration, depending on what the restoration plan comes forward with and our ability to look at that, the Department of Ecology has a responsibility to determine if a water right will be necessary or not. There's different parts of state law and case law that we would look at. So we're ready for that to come forward, and we'll know what our answer is once we see what the restoration plan is. And in terms of the CalPortland needing a water right for the work they're doing right now, Pete, I know that there are several water rights that CalPortland has. You might be able to cite what those are and their quantities and other things.
Well, we have a water right for our makeup well that we use to get water for processing, but that's I think that well will provide 600 gallons a minute, and even though we use a lot of water in our process, we recycle more than 95% of the water that we use, so we have more than adequate makeup water for our process as we work today.
Could you show with a pointer where your wells are on this schematic, or could Lori show where those are?
Actually, our well is well below all the wells on here. Our well goes down to about 1,000 feet, and it's screened at about 600 feet, and the deepest well shown here is about 300 feet below sea level. So that water that we take for our operation well is in I think 2 or 3 aquifers down below what's shown here.
Thank you.
Don, if I just one more point, but by way of elaboration on what Sally said, is that people shouldn't assume that a water right would necessarily be required just because water could be used for restoration purposes or putting in the marsh. And by way of example, when the Port of Seattle built the 3rd runway at SeaTac, that argument was made about the use of water to restore wetlands, water that was going to come from the project, and ultimately the Supreme Court affirmed what Ecology's determination was, that a water right was not required for that use. So it isn't an automatic.
And as long as we're talking a little bit about water rights, I guess an example I would use on a different water question that may be in the package is that what about dewatering? Is that an allowed use, or is that allowed to be done? Dewatering is a regular part of a lot of construction that's done around our communities in our state and elsewhere. Safeco Field, for example, needed to be dewatered as they built that, and it continues to have water carried away from the area, and that does not require a water right. When a bridge is built, that you need to dewater an area so that you can do your construction in your building to set your at depth foundations and things. A water right's not required. So I know that often comes up as a question, and I think that's probably in questions from the town hall meeting that we'll be answering.
Thank you. Pete stated that there is 10 years of monitoring data within the watershed. This would imply that Glacier or CalPortland has been planning expansion soon after the ink dried on the original agreement. How does this engender trust for a success of a newly negotiated settlement?
Well, I think some of the groundwater data was collected prior to the original work and was ongoing. And when it comes to the trust issue, I mean, I really think that we need to go back to what the intent was of CalPortland and recognize that I came there in 2002 after the 94 agreement was signed and CalPortland was considering this creek project. The idea was to find an innovative way to access more gravel and be able to provide an opportunity to improve flow conditions in Sequalcha Creek. A lot of people were very interested in that plan and were generally supportive of the plan. There was a presentation to the City Council at DuPont in 2003 presenting that plan. And I remember coming here on a Saturday, and I think I talked to Mayor Jenkins on that day. I think who was not the mayor at that time, but I think I also talked to Penny Drost, who I believe was the mayor at that time, and I remember there being this idea that, well, maybe this is a good thing, and we do want to see something good happen to Sequalcha Creek, and this was a plan that was entirely enclosed within our property and was something we could control. We went on through a permitting process, did a very thorough EIS, submitted applications, and the Nisqually Delta Association came forward and said, hey, we have some concerns about this project, and we want to talk about it, and we don't like this proposal. And we met with them several times. We talked about what could be done differently. It was clear that it was going to be a difficult issue to resolve with the Delta Association. They invoked the dispute resolution. We entered into a process that took 3 years. We've negotiated for 3 years, finding an appropriate solution. And we initiated that process after an EIS was prepared, after a staff report was prepared, and basically everything was lined up to go to the hearings examiner within months. I think that the fact that we went back and we negotiated with these parties, that we've participated in this process, and now we're here before you supporting a plan that doesn't guarantee any opportunity to mine, doesn't shortcut any regulatory process, doesn't shortcut any public review process, and basically takes us back to stage 1 of preparing an EIS for our mine proposal, is a pretty good example of our willingness to fulfill the obligations under the 94 settlement agreement and our sincere interest in doing a responsible job of collecting the materials, providing the high quality aggregate materials that every one of us depend on. Every one of us, per capita use of sand and gravel in this region is about 14 tons per year per person. That's about 76 pounds a day. So, it is a hard job to find the right place to do this stuff, and we're trying to find the right place to do it. And I think the most important thing to us is at this point is that now we're here, we have renewed these relationships, and are very hopeful that this process will go forward and we can create this as kind of a new template for finding the right way to do things in the future.
Thank you, Pete. These next 2 questions are for Ecology. Is there enough aquifer water flowing into Puget Sound now to have any environmental effects if it is stopped and deferred to the creek as surface water?
Don, I'm going to ask Mike Gallagher to come up to the podium and start to address that. And if you could repeat the question while he's coming up, that would be great.
Absolutely. Is there enough aquifer water flowing into Puget Sound now to have any environmental effects if it is stopped and deferred to the creek as surface water?
And, and let me just start to say that I think the amount of flow was going to be about no more than 5 CFS. Is that what's in the agreement, Bob? Okay.
Well, there clearly is considerable amount of water coming in the Vashon Aquifer and the sea level aquifer and these deeper aquifers into Puget Sound. As I mentioned in the meeting a week and a half ago, this is the mouth of, you might say, a much larger aquifer system watershed that extends to the Parkland, Graham, Spanaway area as a general recharge area. From that point, and even points east of there, west to Puget Sound, that entire area is really a recharge area of rainfall on an annual basis. All of that water generally flows to the west to Puget Sound. The fact that the proposal, as I understand it, is suggesting that something like 6 million gallons a day would have to be pumped at this point up here to dewater, as I understand the proposal, indicates that there's a lot of water flowing through there. It has to go somewhere. If it isn't dewatered here, it goes into Puget Sound. And I think that addresses the question.
Thank you, and you may want to stay put because this next one may impact you as well. Has anyone looked at the sound where this water comes out on the beach to see what the quality of the sound and environment is there?
I don't know of any specific studies. I'm sure there are studies along the beach. I'm not aware of them, but I know there are springs along the sound, and to what degree this potential dewatering would impact those springs, I don't know. All I know is based on this dewatering, there would be some small impacts to water levels near Edmonds Marsh, but I don't know anything more than that at this point.
I would add in that others from the Department of Ecology in our Shorelands and Environmental Assistance Program several years back had walked the shore and had walked the canyon looking at the seeps and trying to understand what might be near shore seeps at different points of the tide. And Bill, I'm wondering if in the Shoreline Master Program update, if there's been some assessments along the shoreline of any of the seeps or the quality of the water.
They haven't been assessed, they've been identified and characterized in the Shoreline Master Program update, but no technical analysis is done. The Ecology grant did not allow for that level of detail and analysis to be performed. It was simply a characterization.
There was also some information on the seeps in the original EIS for the mine project completed in '93, and also some discussion of the seeps as part of the SEIS for the North Sequatchie Creek project.
Pete, I think one of your consultants might have, no, okay.
Okay, previous comments have implied that the Vashon Aquifer and underlying dewatering water aquifer are not connected. How does CalPortland's groundwater modeling contain this when we have clear examples of contaminants from the logistics gate and landfill number 5 reaching the lower aquifer, which would imply connectivity? How is DuPont different than those areas?
That is a hydrogeologist question. I will ask Ms. Herman to please come and answer that.
I'm ready for this one because I've seen a lot of comments about it, and I got 2 slides, this one and the next one, which is the wellhead protection area. Just real quick, I want to leave that one on for a second. Just real quickly, I think everybody understands that water flows real easily through sand and gravel, right? And it doesn't flow very easily through silts. And I think Mike explained that the Vashon Aquifer is separated from the sea level aquifer by this aquitard. And we actually have a lot of data on that. We have hundreds of borings that have gone through that and understand that. There's work that's been done by the USGS. There's work that's been done by Hart-Krauser and Woodward-Clyde in many different studies that show the understanding of this aquifer, this aquitard, which is silts and fine materials, and then this aquifer, which has been tested by Hart-Krauser and others. And I think the thing that I want to show you here that's really interesting, and I think it's the proof, it's the ground truth of this. It's this water level, which is in the Vashon, and this water level, which is in the DuPont. Because when aquifers are hydraulically connected, they will have the same water level. if you were to put a well in here, screen it right there, that would be the water level. If you were to put a well down here, that would be the water level, because that sand and gravel is all hydraulically connected, because that water can move all through that gravel. The reason this water level is so high right here on top of this aquifer, but it's not right here, is because that aquitard is missing. So that aquitard effectively perches this Vashon aquifer up on top of it. So this water level is 190 to 200. This water level is 70 feet. Just the fact alone that those water levels are so different is really proof that they are not hydraulically connected, because flow in these aquifers is governed by Darcy's law. And I don't want to get too complicated, but the flow is really pretty simple. It's based on two things. It's based on the permeability of these materials, very permeable sands and gravels, and low permeability silts, times the gradient. And the gradient is just the slope of the water flowing in this zone, or the slope of the water flowing in this zone. So very little gradient actually through this zone, because it's the surface water and the groundwater are very flat. But there's a lot of water flowing through here because the permeability is so high. So the flow is equal to the permeability times the slope. And maybe that's going to be confusing to you. But this is very high permeability. This permeability is 100,000 times greater than the permeability in this aquitard. And so when you're looking at flow from this Vashon aquifer down to the sea level aquifer, you're looking at a very low permeability. When you look at flow in this aquifer, here's the gradient. This is the slope. So it's a little bit closer here. I saw a comment about, holes through the aquitard. And there have been some studies done by USGS in the fort associated with the TCE plume that they have over in the logistics center. And you can see that these water levels are a little bit closer together there. And that's because this aquitard is a little bit thinner. And when you get down to details of this unit, which is actually a geologic unit, there are some layers of sand that they have found through here, and that provides a hole for the TCE, which doesn't flow with water. It just sinks. So it's been able to get down through some of those sand layers and down into the sea level aquifer. But the other thing I want to show you, besides this proof that these are not connected just based on 130 feet of separation, is that this dewatering zone, it's real important. Everybody understand, we're dewatering for mining. The dewatering is going to occur here. Out in this direction, there's just going to be a change in the water level. It's not going to be dewatered. So all of this water is still going to be there. There's still going to be 80 feet of water in the Vashon aquifer beneath the city of DuPont and Edmonds Marsh outside of the mine. What we're doing is just changing the slope of this water surface right here. And that slope will extend potentially, our estimates are beneath Edmonds Marsh, and there'll be a foot or two of drawdown, but right now Edmonds Marsh varies by 7 or 8 feet every year. So we're going to change it by 1.5 feet. So now I want to talk about the sea level aquifer, because that's the water supply aquifer. And it gets its water, remember permeability, so this is the permeable zone, times gradient, that's the slope. So this is really low permeability. It's not getting any water through there. It's 100,000 times lower than the Vashon aquifer. So if flow is equal to permeability times gradient, there's not any water going through there. But this is permeable, and it's got a nice gradient. So where's the water coming from? The water for these wells is all coming from this area. It doesn't want to go through the silt. It wants to go through the sand and gravel. So now I want to show you the next slide, which is, so here's Edmonds Marsh, here's City DuPont wells. And the next slide is the wellhead protection area that was done by Gray and Osborne. And what it shows is that the water, here's the mining area. This is where we're going to dewater. There's going to be some water level changes to about here. But where's the water coming from in a horizontal standpoint? It's coming from the sea level aquifer to the east, where that slope is moving that water through the more permeable sea level aquifer to the wells. That's why I didn't do this. You know, this was done by other hydrogeologists, but basically it's showing the same thing. This is where the water is going to come from. This is where the water does come from for the water supply wells. So does everybody kind of get a sense of that? That the dewatering area is here. It's here. It's in the Vashon aquifer. It's not in the sea level aquifer. And then this is water from the wells that comes from the sea level aquifer below, a pretty thick aquitard, and that water comes from this area. So, and it's kind of, Pete mentioned this. This is uphill, water flows this way downhill. This is even further downhill. So water quantity and quality in the sea level aquifer in the city's water supply aquifer will not be impacted by the dewatering. And that's why every hydrogeologist says that. And everyone who's looked at it says, yeah, they won't be impacted. It's a non-issue, really.
Can I ask you a question?
Mm-hmm.
What is that 10-year, is that 5-year,
Yep.
1 year? What does that mean? What's the significance of that?
That means that it takes 1 year for the water from here to reach the wells. It takes 5 years for the water from here to reach the wells, and 10 years. So that's there's different planning, there's different plans that are made for, you know, water that can get to the wells within a year or versus 5 years or 10 years.
Do you know anything about the wells that were in the historic village?
Yes, I do.
They're in the
Vashon. There are 2 wells that aren't used anymore because they had bacterial impact issues.
Would you say that wells that are in a shallow aquifer have a tendency of being contaminated, have a tendency, a greater tendency?
Yes, they're much more susceptible to it because, especially in an area like this, where the surface soils are so permeable, you change your oil and you spill something, it just trickles right down.
And then also, is the Vashon aquifer, is it affected by the amount of rainfall that we have every year? If we have a real wet winter or a dry winter, does that have a tendency of affecting a shallow aquifer like the Vashon?
Yes. Okay. Yes.
Thank you.
Yes, I understand we have 2 wells that are located up in Hoffman Hill area.
Yes.
What aquifer do they penetrate?
I know that they're the deeper zones. I'm not positive if they're the sea level or deeper. It is the sea level. I think so. They're actually, one of my colleagues at Aspect Consulting drilled the wells, but I wasn't involved.
Staff, let's confirm that, please, and get back with Councilmember Westman. Thank you. Next.
Before you leave, you may have already touched on this, but just to clarify, are there windows in the aquitard that separates the Vashon and sea level aquifers?
You know, that there are, like this aquitard, for example, and the way that this has been drawn on that cross section.
Erin, could you please pull up that drawing, please? Thank you.
Is really that cross section, that particular aquitard, the extent of it is based on some work that the USGS has done. It's in actually the 2005 Logistics Center TCE contamination report, and so the thickness of this aquitard is based on a number, like I said, quite a few borings, and it's pretty thick in this area, and you can tell that by the difference in the water level. You can see that it thins as it kind of goes over towards the east, and because of this TCE plume, they have found some sand layers that they think are allowing the TCE to kind of migrate downward. It's going to be a little bit lower in permeability. I mean, it's going to be a little bit less transmissive, a little bit more transmissive over here because it's thinner. And as an aggregate, this is made up of a lot of different layers. Like when you look at the cross-section that's in the Gray and Osborne wellhead protection area, it's really, there's intrabedded layers of sands and silts and tills. But as an aggregate, this has got a lot of low permeability material. And I guess what I was trying to show you is that this head difference there just verifies that. I don't know if I answered that question well.
Thank you. What will be done with the millions of gallons of water which will come to rest on the bottom of the mine?
Yeah, I guess, I mean, that's the short answer is that, you know, the plan needs to be developed exactly how that's going to be handled. But the fact is that these are highly permeable gravels in this area, and that by knowing what the volume of the water is, the permeability of the material, you can determine how big of a infiltration pond needs to be. And so the water would be expressed as springs in the mine, be collected into a conveyance system, you know, a depression in the Kitsap, run through what we're envisioning as a couple of wetland complexes that would effectively, you know, take any additional silt or that type of material out, and then be conveyed to this infiltration pond where it could just soak back into the gravels and go exactly where it does now. I mean, and that's one of the things that gives us confidence that this can be done too, is that, you know, the water, all the water that currently comes out of the Vashon Aquifer in this area flows into the bottom of the mine. It just happens underground, so you can't see it. So all we would be doing would be basically intercepting that water and shuttling it over to the same place and infiltrating it into the ground in much the same manner as it does under the current conditions.
Thank you.
And Pete, I would also observe that infiltration process, that's part of the reclamation planning for the mine. So there would be opportunities for public discussion of that process, what that would end up looking like, and how that would work out. That's far from determined at this point. That would be a part of the public review process to some extent.
Councilmember Coffey has a comment.
I have a question. I don't know if Mr. Kingman would answer this, but do we have examples of existing infiltration ponds in DuPont? Is this kind of part of our stormwater system?
Yes, it is. We have regional ponds throughout DuPont that utilize, that pick up the stormwater, provide water quality, and then it's infiltrated back into the ground. As is indicated in the cross-section drawing, the Vashon Aquifer is very permeable. I mean, it has some of the highest infiltration rates known. And as a result, water moves vertically and horizontally through the Vashon Aquifer amazingly fast. We have no problem with stormwater runoff in DuPont. A testament to that would be to water your lawns and tell me how long it takes before the grass turns brown and how much your water bill is. We infiltrate the water, just it goes straight down.
Thank you. Can the city have Gray and Osborne determine where our drinking water is recharged? Do we know the answer to that?
Excuse me, was the question, could Gray and Osborne or has Gray and Osborne?
Well, the question is, can the city have them determine where our drinking water is recharged? I suppose another way to ask that would be, have they determined, or do we know where our drinking water is recharged?
I would believe that answer is provided in the Water Comprehensive Plan.
Okay, and then the second question is, and there's actually two questions that basically are the same. Does the city have enough water to build out Ecology Village? And is this listed in the comp plan?
Again, the city's Water Comprehensive Plan is looking to the ultimate build-out population within the city of DuPont and providing water for all the businesses and all the residences within the city of DuPont at build-out.
Okay, we can restore Sequology Creek without dewatering and pumping. Why are we allowing CalPortland to start this process? Can't the creek be restored without mining the south parcel? And then there's another question that...
Can you repeat that, please, Tom?
We have a few questions that are kind of along that line, and it's basically, the statement is that we can restore Sequatchie Creek without dewatering and pumping, and why are we allowing CalPortland to start this process? Can't the creek be restored without mining the south parcel? And another question that is related to that is, why does the city need CalPortland to restore Edmund Marsh? And I believe the question probably has been answered, but if anyone would like to add to that.
Yeah, I would say, you know, one of the things I thought about mentioning earlier was that in terms of a restoration project, getting funding for restoration in Sequatchie Creek Basin would be a difficult one under the current planning environment. There's a lot of other watersheds that rate better when you score them for the amount of quality you can get or amount of restoration work you can get, given some of the structural issues that would need correction. And so it would be it would take a long time to get funding for this project. And I would say one of the things that we, as negotiators, I think hoped would be attractive to the city and to people that were interested in restoration of Sequatchie Creek is that this current supplemental agreement really starts a new process, and one of the first parts of that process is funding this restoration plan. And if nothing else, if that's as far as the process really goes towards allowing a south parcel mine expansion, at least at the end of a couple of years here, you have a restoration plan which could be used, you know, absent further funding from CalPortland, further mining activity. It could be used to develop a restoration effort over the years as you could find funding available. So at the very least, the process brings a result forward pretty quickly that would be of some long-term value to those that are seeking creek restoration.
Thank you. We're getting down to the final two comments. Thought that would inspire joy. It seems that the ability for citizens of DuPont to move forward with restoration at Sequatchie Creek as they see fit, independently of the settlement agreement, meet and confer parameters and delays and more permitting, will forever be tied to this debate and its timeline. Where is the opportunity for citizens to control their own destiny? The entire thing or the? Okay. It seems that the ability for citizens of DuPont to move forward with restoration at Sequatchie Creek as they see fit, independently of the settlement agreement, meet and confer parameters and delays and more permitting, will forever be tied to this debate and its timeline. Where is the opportunity for citizens to control their own destiny?
Councilmember Trotter?
I think at the town hall meeting that Pete said that he would, you know, CalPortland would welcome other contributions to the, you know, financial aspect of the restoration project. And, you know, being the CPA on the council, it all comes down to dollars. As for, you know, most any project that goes forward in town, you know, why isn't downtown built up? Why don't we have a grocery store? Why don't we have a swimming pool? Why don't we have a skate park? It all comes down to dollars. We need the dollars to make these things happen. And the restoration of the creek is not necessarily tied to the mining project. The restoration of the creek is tied to a financial backing to make that happen. And the CalPortland is just, in their negotiations with Ecology and the Environmental Caucus, has agreed to step up to the plate and help out in the financial arena to make this happen. Now, you know, if somebody else can step up financially to, you know, an awful lot of money has been spent on the hydrologists, on the subject matter experts, on the people who know a lot more about restoration and hydrology and geology and plant biology and botany and, you know, all of that than anybody in this room, if we put our, you know, discretionary income together, could probably pay for. And it's been done over a number of years. And it's going to continue to, you know, keep needing to be done to develop the project. I mean, it's going to cost $200,000 just to come up with the plan. And then there's the cost of you know, doing the SEPA stuff and the SEIS, and you need to do all these studies to determine what the impact is going to be before you can do these projects. And so far, nobody has offered to go through the planning and the project development process that the city, that is the standard operating procedure of the city. You know, you submit a permit, you submit an application for a permit, and there's dollars attached to that. You have to do your SEIS, there's dollars attached to that. You know, if somebody can come up with the dollars to pay for that and to make this project go through, then the citizens, you know, are perfectly willing, are perfectly allowed to go ahead and, like we've said before, anybody can submit an application for a development project or some sort of a project in town, regardless of how ridiculous it is or how much everybody hates it or whether everybody likes it. Anybody is entitled to submit an application and to go for their permits if you follow the right steps. And you know, so far nobody else has come up and offered to go through the permitting process to do the project. So no, yes, citizens can do this. They just have to go through the permitting process to do it.
Thanks. The costs and permitting aside, what I see and what I understand that's before us that we're going to deliberate on and continue to ask questions and continue to take public comment on is a process moving forward. And my hope, my expectation, and what I believe is a common understanding of this panel is this process is a partnership between all of you, the city, and our residents, and that there will be opportunities for the city to step up, the residents to step up, and as that person asking the question said, control their own destiny, to be an active part of this process. And we do, in our community, have an amazing group of dedicated citizens that are very passionate about this issue, and they put in a lot of time and energy and effort to restoring and improving certain aspects of our watershed. And I hope and expect and understand that that will be honored and that will be valued, and they will be brought in as part of the development and the implementation of this watershed plan and this restoration plan, so that in essence we are controlling our own destiny in partnership with all of you, who, as we've talked about, is a necessary requirement to make what we all want a reality. We can't do this without JBLM. We can't do this without the permitting entities. We can't do this without active volunteers. We can't do this without the time and expertise and energy of all of you that have gone through this process for the last 3 years, and will continue to go through it moving forward. It will take all of us. It will take us controlling our own destiny, and that's my hope and expectation, that is a common understanding as we continue to move forward. And if anyone sees or understands this differently, please tell me now.
I would like to add on to that a little bit. and I don't want to take too long because it is getting late, but you know, years ago when the Squelch Creek group first started getting fired up again in response to our application, I went to a meeting, a presentation that Don Russell gave on the creek, and one of the things I said, hey, I think there really is an opportunity to work together here and find some things going forward. I've seen the work that the Squelch Creek group has done in their effort to restore the creek, and talk to folks and understand that they're passionate about that. And you know, when it came down to listing you know, who specifically would be included as invitees in the settlement agreement, we were all for including the Squatch Creek Watershed Council, despite the fact that they, actively maintain a website opposed to our operation and the mine expansion. Because it's my hope that, and CalPortland's hope, that we can all come together and we can find a way to go forward. And that's the reason that we have to have this stakeholder process involve all these people. Look around. The environmental caucus folks that are here have very good understanding of how to complete a process like this. To have the Department of Ecology and specifically to have somebody at Sally Todef's level participating as heavily as she has in this process is a pretty incredible opportunity. And to have all these data that have been assimilated in the process and all these people who are up to speed and understand what it takes to do a restoration project like this lined up and ready to go. I mean, this is a really unique opportunity, and the settlement agreement really just lays out a way that we can look at this opportunity more carefully and in more detail and identify a path to go forward. And I really hope that we can choose to explore this opportunity fully.
I would also say that from my perspective, I think the Environmental Caucus sees a lot of potential for some real synergy here in bringing the various parties together, and some other efforts that are going on in terms of watershed and restoration regionally. I think that your point, Council Member Trotter, was quite good, that you need some money to get that going. I think that there's an opportunity here that we're excited about, that with this sort of critical mass of bringing the right players together and bringing enough money to get the process rolling, we can really get to something that we probably independently could not achieve. And so the members of the Environmental Caucus have reviewed the process and see some real positive potential in this.
Our final question. Who has regulatory and permitting authority on JBLM? And there's a list of examples, i.e. 404 permit, Corps of Engineers, 401 water quality certification, ESA, I'm not sure what that says, consultation, SMA, HPA, any others?
I will give a partial answer and then check, because I may not have it completely, have the complete answer. But on federal lands, federal regulatory agencies will issue the permits. So the Corps of Engineers would issue the 404, and the 401, along with EPA would be involved. Consultation would be done by the Corps and by EPA. John looks like he probably has some work on federal lands. Maybe you could help me out here. But I don't believe there's any state permitting. U.S. Fish and Wildlife and NOAA could be involved in consultation. I'm not sure if I'm missing anyone else, but those would be the primary federal regulators that would.
Right, and specifically, there isn't, the federal government has made pretty clear that there is not a role for state permitting or local permitting on federally owned land. If the U.S. Postal Service wants to build a new post office in DuPont, the city of DuPont will not be issuing land use permits for it. And the Postal Service makes that very clear to local governments. And that's because of the property clauses and supremacy clauses in the United States Constitution.
And I would also add that with those federal regulatory processes, there would be public review built in, just as there are in your local and state regulatory processes.
Council, our next town hall meeting on this topic is a special council workshop on August the 2nd. That's what's on our plan that we'll be marching towards. The public hearing, town hall or public hearing, depending on how the August 2nd meeting goes, would occur on August 30th. That's the current plan that we're rallying around, unless we get information that puts us at a different juncture. Thank you for everybody's patience and input tonight. We do have a few more items of business on our agenda before we adjourn. We